I recently saw a post on an online forum from somebody wanting to reuse an existing home design. Before they approached the designer with the request to reuse the design and construction documents, they asked the forum if there was a relative rule of thumb or percentage so that they could determine if the required reuse fee was reasonable. The first reply was rather interesting. No self-respecting design professional would sell off a design another client paid for. I understand where they're coming from. I've had contracts with clients where we put in writing that we would not resell their custom home design. Although there's a lot of merit to that approach, for the most part, I have to say I lack self-respect. Much of my career has been designing homes specifically for reselling. And yes, a certain amount of thought should go into the site plan and the orientation for every house. And for that reason, or others, it might be your choice not to reuse your existing designs. But not all people can afford custom architecture. Does that mean that they only deserve to live in mass-produced cookie-cutter boxes? Now, reusing one or more of your current designs might just be an opportunity to provide the world with excellent design at an affordable price. And maybe some residual income for you too. So how would you reply to that question? Now, first, we have to be mindful of the antitrust laws. Price fixing is an agreement among competitors to raise, fix, or otherwise maintain the price at which their goods and services are sold, even if we don't agree to charge the exact same price. So any figures that I share are simply to be used for illustrations. With that said, in business, a royalty is an ongoing payment made by one party to another for the continual use of an asset or property. And usually this payment is in return for some intellectual property or copyright, which enables the reuse of software, literature, and other creative works like architecture. So, does it sound better to call it a royalty instead of a reuse fee? Now, royalties are usually paid as a percentage of the sale price or a set fee per sale. Now, one helpful person in that social media thread replied with this. Now, I consider about half of my fee for residential work the intellectual property portion. The other half is the technical service portion. And if this guy is doing 600,000 budget houses for $20,000, I would expect to pay at least $10,000 for a developed design. Now that was a very practical approach and an easy one to justify if you're already structuring your construction contracts in two parts, the design phase and the construction drawing phase. Another suggestion is to check out the online website selling pre-drawn house plans. Now, what are others charging for a similarly sized and shaped house? Now remember that nearly all those sites, except the ones owned by the designers themselves, only pay out 30 to 35% to the designer. So if the asking price is $3,000 for the plan, the designer only gets about $900. I'm just saying. Now also, it's vital to structure every transactional element that can happen in a reuse agreement. Now whether that sale is a one-off home for a homeowner or if you're working with a developer, especially if you're working with a developer. This causes one of the most famous royalty stories to come to mind. In 1981, inventor J.J. Lawrence licensed a secret formula to J.W. Lambert and Lambert Pharmaceutical Company, ultimately settling on a $6 royalty for every 2,016 ounces, to be paid to him and his heirs, executors, or assigns for as long as the product is sold using that formula. Now the two men never specified on an end date, and neither man likely could have imagined that 140 years later, Listerine would become a household staple worth more than $500 million. And after some time, the recipe automatically became part of the public domain, and the makers of Listerine sued to terminate the royalty contract. Because the formula was no longer secret, the company argued that there shouldn't be any need to pay those royalties. But in a landmark case still taught in law schools today, a court sided with the royalty owners. To sunset a perpetual contract without cause, the court said, would be to rewrite the contract for the parties without any indication that they intended such a result. Now, it seems to me the court is saying that using your intellectual property has less to do with the property itself and more to do with the agreement to use it. I have a lot more to say about this, but I've taken enough of your time for today. Now be sure to catch next week's Monday Minute video when we dig a little deeper into the royalty and licensing agreements. And meanwhile, look for the license agreement and the 4 licensing certificates that are published in the Designer's Doc library. They're items 2.06 and 2.07. If you don't have access to the Designer Docs, look for them in the aibd.org/store. Members get access free. Non-members don't get access at all. You'll have to join. Give us a call or email us and we'll be happy to help you do that. Now look them over, and next week we'll go over the verbiage to understand what rights each one is giving to the purchaser and what rights are being preserved for the designer. Now, what experience do you have with royalties? Anything you've learned along the way? Let us know in the comments below. Thanks for watching this entire video and have a triumphant week.